Good afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. We would like to welcome you to our webinar today entitled Discrimination and Harassment Protections for Public School Students. Today, I'd like to introduce to you Paul Sherman, who has been with the DPI Pupil Non-Discrimination Program as a consultant since 2007. He holds an undergraduate and law degree from the University of Wisconsin at Madison. Prior to joining the DPI, Paul taught high school social studies and practiced public benefits law. It's my pleasure today to introduce to you Paul Sherman. Paul?
Thank you, Bonnie, and thank you all the participants for joining us today. I'm very happy to be with you and happy to assist Facets in the important work they do in sharing information about students and public schools. I hope that everybody is having a nice kickoff to the school year. It's certainly been some nice weather recently, and I hope that continues. I'm going to talk today about Wisconsin's pupil non-discrimination law. And as Bonnie mentioned, please feel free to type in any questions that you may have. And as we'll take those as they come in and as they're appropriate. We'll also pause and take some time at the end of the presentation to make sure that any questions you might have will be answered. Wisconsin is pretty unique in terms of its pupil non-discrimination law. It's actually one of the oldest in the United States. It's got a history that goes way back to the 1940s. Following World War II, people were very concerned about what had gone on in Europe, and they adopted in Wisconsin our pupil non-discrimination law in response to that. That law was revised in the early 1980s, and it's been pretty much intact as we see it now since then. So it's got quite a history behind it, long expressed concern of protecting students in the public schools against discrimination. You'll find Wisconsin's pupil non-discrimination law in Chapter 118.13 of the Wisconsin statutes, and there are administrative regulations associated with it in Chapter PI 9 of the Wisconsin Administrative Code. And basically, in sum, it provides that no person may be denied admission to any public school, participation in, the benefits of, or be discriminated against in any curricular, extracurricular, pupil services, recreational, or other program or activity in the public school. And so that basically is what the law sets out in terms of the rights that students have in accessing a school district's public education program. I want to point out here that the law only applies to Wisconsin public schools. The law in our department has no jurisdiction over private schools in Wisconsin. That's the way the law was written, and we don't enforce non-discrimination laws in private schools, even if those private schools are participating in one of the parental choice programs or in the special needs scholarship program. So if you have students attending private school, these provisions will not apply to the students in the private school. The pupil non-discrimination law protects students from discrimination on a wide variety of what we call protected classes, and you see those spelled out on the screen here. Everything from sex, race, and religion, to disability, to sexual orientation, marital or parental status, ancestry, creed, pregnancy, etc. That's a much broader set of protected classes than we find specified in federal pupil non-discrimination law, and that's another one of the ways in which our law is unique. One thing I want to point out here is that this is the pupil non-discrimination law, and the department generally interprets that to mean that The policies and procedures I'll talk about, our authority to regulate schools in this matter, only applies to claims of pupil discrimination. Sometimes a parent will call me and they will express the belief that they as parents are being discriminated against. This particular set of laws does not apply in that situation. And a little bit further on in the presentation, I'm going to talk about some options for filing federal non-discrimination complaints. And in situations where a parent is feeling that they're being discriminated against, not their child being discriminated against, usually that federal option is what's the appropriate way to resolve that type of concern. There is, I understand, at the moment, some proposed legislation in the Wisconsin legislature that's going to make some minor changes to Wisconsin's pupil non-discrimination law. And one of those proposed changes would be to include parents as persons who are protected by 11813. So if you have any concerns or interest in that particular aspect of the law, it might be the appropriate time now to contact your assembly person or your state senator and tell them what your thoughts are on that issue and whether or not you think it would be appropriate to include parents as persons protected by 11813. Discrimination under our law is defined as any action, policy, or practice which is detrimental to a person or group of persons and which differentiates or distinguishes among persons or limits or denies opportunities, privileges, roles, or rewards, or perpetrates the effects of past discrimination. There are a couple of different ways that we conceptualize pupil discrimination under Chapter 11813. One is what we call different treatment. And in this case, it would be a situation where a student suffered detrimental treatment based on their protected class status. So they were treated differently in a detrimental fashion, say because of their disability or because of their race or because of any of those other protected classes that we talked about just a few minutes ago. It's important to remember that not all different treatment is detrimental treatment. And what the law prohibits is different treatment that's detrimental. So something that has a neutral effect or something that has a positive effect on a particular student is really not a type of discrimination. We do need to see that the student has been harmed or suffered some detriment as a result of their protected class status. Different treatment can also arise when a school district adopts policies, procedures, or practices that look on their face to be neutral. In other words, they don't mention somebody's race or disability, but when they have been adopted with what the law calls an invidious intent. In other words, despite the fact that they may look neutral, the body that adopted them actually did that with the intent of discriminating, to treat different protected classes detrimentally. So that can be a type of discrimination as well. There's also a concept under pupil non-discrimination law known as disparate impact. And this is where a facially neutral policy, one again that wasn't adopted with that invidious intent, does have an adverse impact on persons in one or more of the protected classes. Okay. So if that's the case, a district can still say that its policy is okay under the law if it can articulate for us that it's necessary to meet an important educational goal and that there are no other comparably effective alternatives available to it. Sometimes we do have parents call and ask about this type of situation where, well, the policy doesn't specifically, single out groups of students, but I feel like it's affecting in a negative way students who may not speak English or students who might have a disability. Is that discrimination? The answer to that is it could possibly be, but it would require some investigation. The administrative code also expands a little bit on what the definition of discrimination is. It specifically says it can include bias, it can include stereotyping, and it can include pupil harassment. And pupil harassment, usually by a student's fellow classmates or students, is probably the most frequent question that I get here at the department from parents and from school districts in sort of along the lines about what is this and what can we do about that. Pupil harassment is defined in the law as behavior towards pupils which substantially interferes with a pupil's school performance or creates an intimidating, hostile, or offensive school environment. This is a relatively high standard. It doesn't just mean, oh, that hurt my feelings. It means that hurt my feelings in a way that substantially interferes with my school performance or really creates this hostile environment. Pupil harassment needs to be behavior that's based on the student's protected class, and that makes it a little bit different from bullying. Right? Bullying might be behavior towards a pupil which substantially interferes with the pupil's school performance or creates that hostile or offensive school environment, but unless that behavior is based on the student's protected class, it's not pupil harassment under the non-discrimination law, it's just bullying. Under Wisconsin law, every school district has to have a policy prohibiting bullying, and it has to have a process in place by which people can file complaints about bullying. But that's a separate process from what exists under the pupil non-discrimination law. So again, sometimes there's behavior there that's bullying, it's harmful to students, but because it's not based on the student's protected class, it's just bullying and it needs to be processed under the district's anti-bullying policy. If, however, the student's protected class is involved, in other words, they're being bullied because of their religion or because of their sexual orientation, that is pupil harassment under Wisconsin's pupil non-discrimination law, and it needs to be addressed as such. There are several requirements for school districts under Chapter 118.13, and I think this is very relevant to parents and students. Each school district has to have a written policy prohibiting discrimination. Each school district on an annual basis must provide a public notice of the policy. So if you're ever looking at your school district's website, you'll often see that public notice put on their website. Oftentimes districts will put that public notice in an annual newsletter that goes out to all of the residents of the school district, or they may even publish it in the local newspaper. Okay. The policy also has to be made known in other areas. So you should see information about a district's policy prohibiting discrimination in student handbooks. Districts should have non-discrimination statements on all of the publications that they put out. So that's where you would go looking if you had questions about your own district's non-discrimination policies. And of course, most districts these days are posting their Board of Education policies on their website, and you will usually find the non-discrimination policy in that area as well. Districts are also required to designate a specific person who has been appointed to receive and investigate non-discrimination complaints against the school district. And that person needs to be known district-wide, and that person's name should be readily available to you if you have any concerns and you contact the principal's office or your district central office. They should be able to point you to the appropriate person to help you through the complaint process at the district. If a person elects to file a non-discrimination complaint under Wisconsin law, there are several provisions that apply. The district needs to provide a written acknowledgement that they have received your complaint within 45 days of the day that was provided to the district. They also need to completely resolve the complaint all the way through whatever appeals processes exist within the district within 90 days of the date you received the complaint. And for those of you who have experienced these types of issues before, you know that why the law is doing this. It's important that these types of serious concerns get resolved as quickly as possible. There is a provision in the law that allows that 90-day timeline to be extended, but that's only if the complainant and the district agree that additional time is necessary to conduct a thorough complaint investigation and reach a resolution. So quite frequently I find that when we receive appeals here at the department regarding district determinations, districts have gone beyond that 90-day timeline, and that's something we're working with districts to make sure they understand that that is a legal requirement and the reasons behind that. When the district issues its final determination on a non-discrimination appeal, they also need to inform the complainant that they have the right to appeal that decision to the state superintendent. And they should inform the complainant that that appeal must be received here at the department within 30 days of the date of that decision. So if a district conducts an investigation and it substantiates that the student has been discriminated against or the student has been harassed because of their protected class status, the district then has a legal obligation to either stop that discrimination or to take steps reasonably calculated to stop the harassment that the student has been the victim of. This is often a point of frustration for complainants in pupil non-discrimination issues because the law doesn't place an absolute obligation on the district to stop pupil harassment. It places this obligation for the district to take steps reasonably calculated to stop the harassment. So the district, in its best judgment, depending on the facts of the situation, needs to make a reasonable effort to decide what will stop the behavior and then implement those steps. Sometimes on initial review, that doesn't seem to be sufficient to the person who filed the complaint. They think the district should take more serious steps, but it's really up to the district in the first instance to decide what they're going to do. Now, that doesn't mean that the district can say, okay, we tried something, it's not working, that's all we're going to try. In cases where the district has substantiated harassment based on protected class status, they have flexibility to decide what steps they're going to take. But if the steps they initially take don't solve the problem, they have an ongoing obligation to try other steps to ensure that that harassment stops. So that's something to keep in mind if you're involved in a harassment complaint and you feel that the district has not taken appropriate steps to start with. You need to recognize that the district has a little flexibility to try things first, but then to remember that the district doesn't just get to give up and that you as the complainant have the right to insist that the district try other methods to get that harassment to stop if what they've initially proposed and implemented doesn't solve the problem for you. If you find that you've disagreed with the district's determination that, for example, harassment or discrimination did not take place, or you find that the district has not taken steps reasonably calculated to stop harassment or discrimination that they have determined has taken place, You do have the right to appeal here to our department. As I mentioned earlier, you have to do that within 30 days of the district's final determination. When we receive that appeal from you, we'll ask the district to send the record that it developed over the course of its investigation and what it's done to address any harassment or discrimination that they found. And we will determine whether the district correctly applied the facts and conducted a fair and appropriate investigation. If we find that the district did not do so, then we have the authority to require the district to develop a corrective action plan to make sure that the concerns of the complainant are addressed in the legally appropriate fashion. As I mentioned earlier, you do have the option to file a federal pupil non-discrimination complaint. Their protected classes are a little bit more limited than what we have in Wisconsin. If you feel you've been discriminated against based on your race, color, sex, age, disability, or national origin, the U.S. Department of Education Office for Civil Rights may be able to provide you assistance in filing a federal complaint under one of the various federal non-discrimination statutes that apply in the public school context. The best way to find out more about what that option and what their complaint process looks like is to contact their office in Chicago, which is their regional office that covers all Wisconsin school districts, and I have their telephone number there for you. As you've seen as we've gone through the Wisconsin law requires you to file that initial complaint with the school district first, and then wait until the school district issues the final determination before you can appeal to DPI. Some people are uncomfortable. They feel like they've sort of exhausted all of their options at the local school district. There may be a lack of trust, over some of these issues, and they don't really want to have to go through that district process first. In that case, if you are in one of the protected classes protected by federal law, probably your best option is to go through the complaint process with the U.S. Department of Education Office for Civil Rights, because they don't have that similar requirement that you go through the district's process first. They can just open up an investigation independently of what's going on at the school district to that point. So that often is a more attractive option for people who meet those protected classes and don't want to use the district process that's available to them first. In addition to our authority to review appeals of pupil non-discrimination complaints, we do a little bit of monitoring around this area with school districts. Every 5 years, we require school districts to complete a self-evaluation. The last one was completed in 2017, so we're looking at a couple more years before we're in that process again. Part of the self-evaluation process is that the district looks at several different criteria around how they're performing in terms of preventing pupil discrimination in their school districts. There's an opportunity for public involvement in that process. And at the end of the process, the district develops a written report summarizing what they found during the self-evaluation. And that report needs to be made available, well, it needs to be approved by their school board, and then it needs to be made available for public review. So if you have a particular interest in how your district has been engaged in the self-evaluation process, you certainly have the right to contact the school district and ask to see a copy of that 5-year self-evaluation report, the last one from 2017. And then, of course, if you have interest in that in a few years here, be on the alert for an invitation coming out from your school district to have potentially the public participate in the next round of self-evaluation. We also annually collect from school districts the number of complaints of discrimination that they received during the previous school year. This is just a sort of a raw number, the number of complaints that they received. We don't look at whether any or all of those complaints were substantiated, but we do break it out by all the different protected classes. And that information gets reported to the state legislature every 2 years in our biennial report to the legislature. That information is also should be available to you through requests through the school district, or if you have information or a request about a particular school district, you can also contact me and I can provide you those numbers. Consistently, we find, really over the last 10 years at least, that the highest number of complaints received by school districts statewide are in the area of sexual harassment and sex discrimination, followed by racial harassment and race discrimination, and then the third highest number of complaints received statewide is in the area of disability protected class. So again, that information is available to you either through the school district or through me if you have any particular questions or concerns about that. So I've reached the end of the information that I wanted to provide to you today. I invite you to contact me directly at the department, either by phone or email, if you have any general questions about the pupil non-discrimination law in Wisconsin, or if you have any specific questions or concerns about your child and their school and any policies or procedures or harassment that they may be experiencing, I'm happy to help you. And with that, I guess, Bonnie, we'll just ask once again if anybody has any questions they'd like to submit, and I can answer those before we complete our time together today.
Okay, well, I do have one, and I believe it might be of parent interest, and that's in the discussion of pupil non-discrimination, can you put bullying in perspective with all of this and how bullying law affects the non-discrimination law, et cetera?
Mm-hmm. Well, if we go back, and when I don't know, just do that, I'll back up here so we can look at that together. Okay. So any behavior which substantially interferes with the pupil's school performance or creates an intimidating, hostile, or offensive school environment, if it's based on the student's protected class status, so race, religion, sex, sexual orientation, disability, those categories that we discussed before, should be considered pupil harassment under the pupil non-discrimination law. In other words, if you come in and you say, I'm being harassed or I'm being bullied because of my protected class status, the district should take that to be a complaint of discrimination under 118.13, and then all of the rules that we talked about, acknowledging your complaint within 45 days, fully resolving the complaint within 90 days, informing you of your right to appeal to the Department of Public Instruction. Those policies and procedures should apply because that behavior is based on the student's protected class status. If, on the other hand, you raise a concern that, my child is being picked on, it's very significant, it's interfering, they don't want to come to school anymore, their grades are going down, and they're being picked on just because the student doesn't like my child. They can't get along with each other. or some other reason, that's bullying, and that is something that would be resolved under the school district's anti-bullying policy. And our department, under the law, doesn't have any authority to review district bullying policies, or whether they conducted an appropriate investigation, or whether they took appropriate steps to address the bullying. So unless there's a protected class involved, the non-discrimination law does not apply to instances of what we would just sort of usually describe as bullying. So not all bullying is pupil harassment, which is prohibited by the non-discrimination law. Bullying is a bigger category. The pupil non-discrimination aspect is smaller because it only involves the protected classes. And I know that's a lot of words, but
no, I think that helped to make the distinguishing factors there available for people to take a look at. I do have another question,
sure.
And it is, what happens if a corrective action plan was warranted and one was issued? Who monitors that to make sure it happens?
Yes, and we monitor that to make sure that it happens. So a district, when they submit a corrective action plan, will say, we are going to do X, Y, and Z to address this issue. And then as they accomplish X, Y, and Z, they provide us evidence that they have done that. Now, if a parent were to call me after all those steps were completed and say, but my child is still being harassed, or the district is still doing X and they promised they wouldn't do that, then that would be a situation where I would either have to ask the district to take additional steps, or I would recommend that the parent file a new complaint about that issue, essentially saying that the district hadn't taken the appropriate steps.
So how often does a follow-up complaint happen?
That has not happened in my experience so far. And like you mentioned earlier, I've been doing this about 12 years now. So and I should also say that our appeal situation is that we don't often overturn a school district's initial determination. They have usually followed the legal requirements in the fashion that they need to. So the fact that we haven't had the subsequent appeal doesn't mean a whole lot, because we haven't had a whole lot of experience with that. So.
Okay. Well, at this time, we don't have any additional questions. If anybody has another one, if you want to type that very quickly in the question box, I can pass that on to Paul. Otherwise, Paul, thank you so very much for your presentation today. I know that I learned a lot, and I'm sure that others that are in attendance have done the same. So thank you.
Very good, and thank you all for taking time to listen today.
This concludes our webinar. I'd like to thank everybody for joining us today. Please be reminded that Wisconsin Facets has over 80 scheduled trainings and webinars for 2019, and that we're in the process of putting together our training calendar for 2020. Please check out our website and register for any of the upcoming trainings that you may be interested in. Also, please watch for the short evaluation that will be coming your way after today's live webinar presentation. Again, thank you to Paul, and thank you to all of us who participated today. Have a great day, everybody.